not speaking up, you won't ever be recorded. So let's go ahead and we'll go ahead and get started here. So I'm Keith Pickering Walters. I'm currently the Vice President of the Livermore Education Association. And with COVID-19 still an issue for the 2021 school year, members may have questions or concerns about requesting reasonable accommodations and about expanding leaves that have been created through legislation. My hope is to present some useful information to you today. If you have any specific questions that relate to yourself, please try to hold on to those and we can certainly speak privately afterwards. If it's something that is about what we're currently speaking about or what we just spoke about, or more of a general question, go ahead and put that in the chat box and then I will get to that as quickly as possible. If it's something that I know we're going to be covering in a little bit, I may skip it and address it at that time. So here we go. So really, what is our district and our association doing about um, keeping us safe during COVID-19? So just a couple of things. Negotiations have been going on. So our bargaining chair and our team members have been busy all summer long dealing with memorandums of understanding and negotiations around all of this stuff. They're currently almost finished with a memo of understanding for distance learning, and then they'll be dealing with upcoming negotiations for hybrid learning, which is if we do a partial return to campus. I don't see that personally happening very soon, but our team will definitely have time to deal with those negotiations before we return. And obviously, there's also been a lot of employees that have been very busy over the summer. All of our nurses have been involved in getting our schools ready for COVID-19, and Amy and I have been around, and a bunch of other folks, and then obviously everyone in the district office and all of our classified staff that have been working on our sites. So we're getting there. So first I want to address leaves. A lot of this is in our contract, so it's stuff that's currently available for people. But just as a reminder, so we have sick leave. We get 10 days per year. If you're full-time equivalent, it's prorated if you're less. So if you're half-time, you get 5. And they can be used in a variety of different ways. Some get used in other banks, like the personal necessity. So if you have a court case that you need to deal with, or you've got some family business or other things that happen during school hours and you can't get out of those or move them to after school, you can use 7 of your sick leave days as personal necessity. You do have to get those approved in advance and notify the district that you'll be using them, but that draws from your sick leave bank for that. On top of our sick leave, we also get 1 personal leave day per year. If you didn't use last year's, it stays in your bank, in your personal leave bank, so that you can use 2 in 1 year, but you don't ever get to use more than 2. Excuse me. So if you haven't used them for 2 years in a row, when we get to the 3rd year, 1 of those turns into sick leave and drops into your sick leave bank. And that's really so that people don't bank a whole bunch of days and then take a really long extended vacation in the middle of teaching time. We also have catastrophic leave, and this is a voluntary program. This was created by LEA years ago. And it was really designed to help LEA members who are dealing with catastrophic illnesses like cancer. So members wanted a way to be able to donate their sick leave to other members. And in order to do that fairly, the catastrophic leave bank was created. And so in order to be able to draw from it, you do have to participate in it by giving 1 sick leave day per year. So you have to join between July 1st and September 30th, and then you can apply for up to 30 days of sick leave credit per catastrophic illness. So if something comes up and it knocks you out of commission, you've got the ability to take this. It is set up through a committee of LEAs, so our president and 2 appointed members sit on that panel. They'll review the situation and then approve that to go out. And I am just going to click one button to see if I can mute everyone. Um, Sorry, I've been using Zoom so much that I'm not 100% sure where I get to mute everyone. That's where I am, and I can sort everyone, but I can't. Yeah, no, I know. I'm in the host one. Um, it's really interesting. Okay. And now I'm feeling like everyone will on the first day of school dealing with the technology. Sorry, Amy, I'm still not able to find it. Yep. Yeah, if you can, go ahead and mute yourself. Everyone, sorry. I'm used to having a master control and I do not see it. Okay, thank you. Okay, so now everyone should be muted. Okay, sorry about that, everyone. So we'll hop back to this. And let me get our other presentation. I have my notes running on one computer and the presentation on another. So this is always fun. Okay. Now, we also have industrial accident and illness leave. And this is one that I honestly have never ever seen anybody use, but this is essentially workers' compensation. So if you are involved in an accident or illness through work and it's work connected, then you can get up to 60 days at full pay through the district. If you have a disability plan, which I would highly recommend, during this time, if you're getting full pay from the district, your payment from the disability plan goes to the district because you can't receive more than your full salary. And workers' compensation isn't something we would normally look at, but because of COVID-19 and the governor's executive order that specified that if you're working, um, that most likely if you catch COVID-19, you caught it at work. Um, and so there's kind of a default in that. There's also a new bill, which I'll get to later, that is expanding that beyond June 5th, because the governor's piece expired June 5th. It was more focused around folks that were working in the grocery stores. Um, so we'll see how that goes. So two really big important takeaways. If you don't already have disability insurance, you should definitely sign up for it. You do have two options, the standard, which is CTA's endorsed vendor, and then we also have American Fidelity, which is offered through our school's healthcare plans and benefits. If you haven't already signed up for the catastrophic leave bank, you may also want to consider that. Again, that's a participatory piece, so you do have to be a donating participant in order to be able to withdraw from that. So now with COVID legislation, there's been some new things that have been developed, and that is the Families First Coronavirus Response Act, the FFCRA. And there are two pieces for it. There is the emergency paid sick leave, and then there's emergency family and medical leave expansion. Um, with the emergency paid sick leave, if you're unable to work because you were diagnosed with COVID-19 and you're experiencing symptoms, you can receive an extra 2 weeks of sick leave at your full pay. Now, this is up to $511 a day, and it's a total of $51.10 over that 2 week period. Um, and so the difficulty piece on this is experiencing symptoms. Not everyone experiences symptoms, so you may be diagnosed with COVID-19, you might be quarantined, but you might still be able to work through telework or distance learning. And so something to think about there. Now, if you're unable to work because you're caring for someone who is quarantined or you're caring for a child whose school or child care center is closed, you can receive up to 2 extra weeks of sick leave at 2/3 of your pay. So this is capped at $200 a day, or 2/3 of your pay, whichever is less. And it's $2,000 total. So some folks are looking at this, especially in case of childcare. Um, as we're trying to distance learn at home, you've got children to deal with as well. Um, the way this legislation works is if you are able to telework, if you're able to do distance learning, you most likely wouldn't qualify for this to do childcare because in theory, you can sit your kid next to you while you're teaching or while you're working from home and still be able to supervise them. But you can use this prior to using your district's sick leave. And unless it's extended, it will expire December 31st. And for the Emergency Family and Medical Leave expansion, this really expands the Family Medical Leave Act. And so this provides paid leave for childcare needs related to COVID-19 for up to 12 weeks of leave. And again, this is only if you can't work or telework and your child's school or childcare center is closed due to COVID-19. The first 10 days of this one are unpaid. If you have sick leave with the LVJUSD, you can use that to cover that 10-day period. And then this would kick in with 2/3 of your regular pay capped at $200 a day. And again, unless this is extended, which there's talk about it being modified or extended, it will expire December 31st, 2020. Now, with workers' compensation, on May 5th, Governor Newsom created Executive Order N6220, and this provides that all California employees who work outside their home at the direction of their employer between March 19th and July 5th, if they test positive for COVID-19 within 14 days of working at their job sites, it's presumed that they've contracted COVID-19 at work, and they would qualify for workers' compensation benefits. Now, Assembly Bill 196, if it's passed, would extend this beyond June 5th or July 5th, sorry, and continue that moving forward. Um, Again, anything happening after March 1st, 2020 through current times would be covered through that. I don't know if that's going to happen. Workers' compensation has always been a little on the tight end of things, and so it's much more restrictive than like our disability plans or anything else. Now, if you don't qualify under any of this and the AB 196 doesn't pass, then the employee would have to meet certain threshold requirements that would prove that their illness came from their employment. And CTA's Group and Legal Services, which are the attorneys that we can refer you to through CTA, they actually don't deal with workers' compensation. So they can refer you though to an employee-friendly attorney who you can contract with to assist you with workers' compensation claims. For some reason, historically, that's never been something that our attorneys have done because workers' compensation is kind of its own lane. Okay, now, reasonable accommodations. This has to do with the Americans for Disabilities Act, and reasonable accommodations are things that we can, oh, I'm missing a D in that presentation, sorry. These are items that we can request from our district to help us to get through something. So if we have a qualifying disability, which could be a mental disability or a physical disability that substantially limits one or more major life activities, so these can be impairments of major life activities such as caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Lots of options there. And this can also include impairments of major bodily functions, including your immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Now, various health conditions may put individuals at what's called a higher risk for COVID-19. These complications are likely qualifying as disabilities under the law. So these are things like chronic kidney disease, diabetes, and moderate to severe asthma. Now, there's been lots of talk about age, tobacco use, and other things that could increase a person's chance of getting COVID-19, but those items like age and tobacco use are not considered disabilities. So that's a real important distinction to think about. But in terms of the chronic kidney disease, diabetes, and moderate to severe asthma, if members have that, they can speak to the district about complications around COVID-19 for some accommodations. So how do we go about requesting a reasonable accommodation? So the ADA and the FEHA, which is the Fair Employment and Housing Act, requires that employers, including school districts, and charter schools, community colleges, and whatnot, provide reasonable accommodations to persons with qualifying disabilities. And the law protects retaliation against employees if they assert their rights under this. So an employer is required to provide reasonable accommodations to employees and applicants with a known disability. So if an employer doesn't know about your disability, there's no way that they can really be responsible to provide any accommodations for you. So that's really where communication is going to be really important with HR. Um, so if you haven't already notified the district, you would want to notify your employer or district that you have a disability related limitation and you may need a reasonable accommodation to perform your job. So a reasonable accommodation request can include a request to telework or perform distance learning. And temporary use of sick leave or other paid or unpaid leave might also be a reasonable accommodation. So where CTA is looking at members needing to use this is especially when we transition back into in-person learning at school, we may have some employees who may not be able to do that. So a reasonable accommodation for some of them may be to request to continue to do distance learning. Obviously, there's lots of talk within districts right now and within the state about can we keep kids that don't want to return or their families don't want them to return, can we pool them together and have teachers who can't return work with those students? So some of this may come about automatically and naturally through negotiations and through the memo of understanding. But if you're super concerned about this, it may be something that you might want to start the process earlier on. Let's see. So under California law, you also have the right to have an exclusive representative with you through this process. So if you'd like an LEA rep, whether it's Amy, myself, or your site rep, to accompany you through this process, we certainly can do that, and the district isn't going to stop you. Um, the interactive process is collaborative and it's ongoing, and it's really a discussion. It's designed to arrive at a reasonable accommodation that enables the employee to perform their essential assigned duties of their position. There are no formal procedures um, to this interactive process meeting. So this is where there isn't a form that you can download from the website to fill out and request a reasonable accommodation. It all starts with a phone call to HR, and I would recommend to go directly to Melissa Thede and speak to her. She's the head of HR, and let her know that you have a possible need for a reasonable accommodations and that you'd like to sit down and have a conversation. Um, Sometimes this process will take multiple conversations, and it may also require you to visit your doctor at some point in time for any verification that's necessary. The employer is not required to provide a reasonable accommodation that imposes an undue hardship. So I'm just going to throw an example in here. So um, if I say, I broke my foot and I'm unable to be in my classroom to teach, the district might not be able to accommodate me with distance learning if this is a normal, regular situation. So during a normal school year, chances are I would go out on disability and the district would not make an accommodation of distance learning for me because it would be unreasonable for the district to put another teacher in my classroom while I'm teaching from home. Hopefully does that kind of make sense to folks? Yeah, I'm seeing some head nods. So I'm going to be emphasizing reasonable a lot through this presentation. And it's reasonable on both sides. It's reasonable on the employee, and it's reasonable on the part of the district as well. Um, okay, and then another key piece is the essential function of the job. So an employer can actually just outright reject an accommodation if that accommodation eliminates an essential function of your job. So if your job is supervision, of students and you temporarily are not able to see, that could impact you being able to do that essential function of your job. So a lot of this will um, take some conversations and talking through with your doctor. Let's see. So here, the employer does have to engage in timely and good faith process with the employee to determine if there's a reasonable accommodation that will allow the employee to perform the essential functions of their job. Let's see, one more piece. Yes, sorry, I covered that piece. I have my notes twice. Yes. Okay. So when it comes to medical documentation, this is a question that a lot of members have. Sometimes they'll get all of this in advance and then go and sit down and present all this stuff to the district. In some cases, that can be helpful. In some cases, it's better to just start with a conversation and go from there. Um, but an employer can request reasonable medical documentation, and it should explain any disability-related limitations and possible accommodations that might enable the patient or you to perform the essential functions of the job. I know in conversations with HR folks, this is where sometimes doctors will get excited or kind of reach beyond what their expertise is and kind of dip into the HR field, and they'll try to recommend accommodations. And it really isn't the part of the doctor to recommend what accommodations you need. It's really the part of the doctor to recognize what disability related limitations you may have, and then HR can help you to deal with what accommodations would better help you with that. I know for members who have sciatica, some folks are able to talk with HR because they need to be able to stand up occasionally. So they may need a sit-stand desk or an adapter for their desk to be able to move their computer up and down. That way they're freely able to sit or stand. That's an accommodation that is fairly reasonable because it's really only about $200 or $300 to modify your desk for that. So that's a simple example. The Department of Fair Employment and Housing is the agency that is in charge of enforcing all of this. And currently, they're recommending that employers temporarily waive medical documentation requirements if it's impractical for an employee to reasonably obtain documentation. So if you can't get to a doctor to get documentation about COVID-19, but you're exhibiting symptoms, you can still kind of go forward with this even if you haven't talked to your doctor about it yet. Now, non-precedent setting is really important with this process because each employee's accommodation is personalized and confidential. The accommodations process is non-binding and it's non-precedent setting. So if a coworker tells you about an accommodation that they received, it does not mean that you can or will receive that same accommodation, even if your situation seems similar to them. So be aware of that. And really the most important thing to remember is reasonable. So is it reasonable for you as the employee to need an accommodation to be able to complete your work? And is it reasonable for the district as the employer to provide the necessary accommodation? So I'm going to give you just a personal example because I actually had to go through this a couple of years ago. My family got, and my dogs got skunked in our backyard. There was a skunk in the shed, big ordeal. Um, I ended up getting shingles about 2 or 3 days after that. And the shingles was on my head and forehead. Um, and being like 44 at the time was really unusual to get shingles that early in age, but it happened. And it felt like someone would put an iron randomly on my forehead at any moment in time, even after the shingles was gone. So for about 6 months afterwards, I needed to use something on my forehead to kind of dull that sensation. And for me, CBD worked, which is a form of medical marijuana. So obviously I'm not smoking it. It was a nice little roll on. But I asked for an accommodation from our district to be able to use that while I was working at school. CBD is non-impairing. It doesn't make you high. It just relieves the pain, the extreme pain of this situation. So I simply had a conversation with them. Then I sent them an email. They sent me confirmation back. I agreed that yes, I would keep it locked up while I was at school, and it was really easy. So even, you know, even things like that can require a reasonable accommodation. Let's see. So I've got some questions in the chat, or really some announcements. We are going to have an open enrollment for the standard disability insurance in November. So members who are just starting with us, they have that first 100, I think 180 days to sign up for the standard automatically. They get accepted. There's no medical assessment or anything else. If you've been with us for a while and you haven't signed up for disability insurance, you may be required to fill out the medical paperwork. And some items might be um, non-qualifying for you because they're pre-existing. When we do an open enrollment, if we get enough members to sign up at that point in time, the standard waives um, those medical forms for everyone. So if you don't currently have disability, you may consider jumping on in November, um, because that can be a helpful thing. There we go. Okay, and then let's see, you will need a note from your doctor. Oh, so in terms of getting that doctor's note, you will usually need a note from your doctor at some point in time. It typically doesn't need to disclose your medical condition. The note should specify what your limitations are. So, for example, if you can't stand for more than an hour without sitting down, if you're not able to lift more than 50 pounds, things like that, would be limitations that your doctor would put in. Um, and then Maureen asked, where does the term reasonable come from? It really is a loosey-goosey term. You're absolutely correct on that. Reasonable, though, is what typically gets put into legal language, legislation, and contracts. Um, because so where reasonable, the best way to think about it is, would a regular general person in that same situation, would they reasonably deal with that situation the same way as you? So, gosh, I'm going to completely take this out of this situation. So, when it comes down to like hostile work environment situations, reasonable comes into play there. And usually, what the attorneys will ask me is is this situation causing a reasonable reaction from this member? So if you stuck a regular, everyday, normal member in that same situation, would they reasonably feel the same way as the member who is claiming hostile working conditions? So hopefully, Maureen, are you shaking your head? Does that kind of make sense? Great. Good, good. Okay. And um, this kind of brings us to the end of the presentation. The largest thing is, if you have questions about this, certainly give Amy or myself a call. We can kind of bounce some ideas off of, or you can bounce ideas off of us. We can kind of brainstorm a little bit and see what might work best for you. Um, but overall, you're going to want to just have an honest conversation with HR and kind of start this process. So, any other questions or comments? Amy, did you have anything else you wanted to throw in there? Oh, question. How does the need for disability affect your STRS credit? So, do you mean the disability insurance, or, um, oh, do you mean like needing an accommodation, if that affects your STRS credit at all? I don't believe that affects your STRS credit, because obviously if you're still working, you would still be receiving your full pay. The district would still be paying their portion of your STRS credit. You'd be paying your portion of your STRS credit and all of that. I do know that for some members who have gone out through disability, so say someone had an accident and their disability insurance covered them, they'll typically get through that first school year. And then if the person still isn't able to come back, the disability insurance will continue to cover you for an additional year. And then they'll usually help you to get out on STRS disability, which can happen at any age. There are different age requirements for going out on STRS disability, and then the disability insurance company will assist you through that process until you're on that. Um, let's see, when we go to hybrid model, are those of us that are 65 or older that don't want to go in person, do we have to apply for accommodations to continue to telework? That's really the large question that's happening, and the situation is that there's no tested cases on this at this point. So when folks have asked, their districts might say, sure, no problem. We've got classes that are going to stay distance learning and that'll work fine for you. Um, Again, age is not one of those disability factors, so it doesn't necessarily guarantee that a person would qualify for a reasonable accommodation. Um, and so right now we're kind of in that beta test situation. So I'm hoping that in the state of California, we're going to have other districts go back to in-person learning prior to us so that we can, Amy's kind of laughing, so that we can experience and see what they're going through so that by the time we're ready for it, we're able to have some kind of case law or some examples set up for that. But I would say if you are 65 or older and you are concerned about coming back in person, I would start having that conversation with your site administrator as soon as possible. Just say, I'm really excited about school starting. I've heard that we may be going back, at the end of first trimester, at the end of second trimester or whatnot. Because of my age, I'm really concerned about COVID-19 and I'm staying as isolated as humanly possible. I would like the ability to stay in distance learning. Is there something that we can set up with my classes so that I don't have to change classes in order to do that? Because right now the district already has a sense of some families that do not want to return, and they've already filled out the survey that says, even if you go back full time, I don't want my kid there. So there will be some situations where members can fall into that. Um, so Maureen, age is a disability requirement of COVID. No, so dis sorry. So COVID, let me roll back to my specific part that I have on there. There we go. So age is a condition that heightens the risk for COVID-19, but it's not considered a disability under ADA or FEHA. So while yes, it does put someone at higher risk for COVID-19, ADA doesn't recognize being old as being disabled at this point in time. Okay. Any other questions from folks or comments? Okay. Yep. Yep. Honestly, I don't know. The blanket decision that happened in March really came more so from the county. Obviously, our district said, yes, we're doing this. And, that first day they sent the kids home. We all came back that Monday after. Then that afternoon they said, if you're 65, or no, actually over the weekend, they said, if you're 65, don't come back. And then we were there on that Monday. And then I think that first Monday, that afternoon is where they said, don't come back at all. And so everyone was sent home. So it kind of the ball got rolling really fast in that situation. So I don't know if there's enough. No, that's fine. Um, that's a really good question. I I don't think I'm totally qualified to answer it. So it's something I'm going to have to research more on. I don't know if Amy wants to chime in here. I do. My understanding is that they have put in filters that are at the standard of which is necessary to protect employees from COVID-19. What you're talking about, though, is the standalone system. So is my classroom isolated from the rest of the system? Or is my classroom linked to two other classrooms that share the same air? And in those situations, I don't have an answer on that. Um, Amy, or we actually have some of the nurses with us today. I don't know if they can speak up on any of that. Shelley, do you want to give it a? Okay, that may be something that's happening throughout the district. I don't know if administrators have been notified by maintenance if all of that work has been done. So it may just be that information isn't totally available yet. And someone also asked a little bit earlier if you're caring for elderly parents and being concerned about going back and forth to work in person. So I would say that that's definitely a consideration. So if that's because there is the piece in the legislation about caring for family members, I know we kind of focused more on caring for children, but if you've got aging parents at home, that's certainly something that you would want to consider um, for that. Okay, wonderful. Well, thank you, everyone. If you have a personal situation that you need to chat about, feel free to give myself a call or Amy a call. Um, you've got our numbers, and yeah, we'll leave it at that. Thank you, everyone, for joining us. And if you're just watching the video, take care, everyone. Bye-bye.